May I, with your permission? Sorry. My apologies. Judgment बताना तो चाहिए. I'm sorry. क्यों नहीं बताया? ऐसा नहीं किया.
For the foregoing reasons, the impugned order and judgment dated 21st of December 2018 of the High Court is quashed and set aside. The appellants are held entitled to protection of para 1.05b of the FTP. The appeals are allowed. There shall be no order as to process.
Sorry.
Notice your submissions also, including your written submissions. Thank you. Very good. Yes, 801.
801 is a consumer appeal, Your Lordships. I am praying for not to be deleted 27th January.
All right.
Your Lordship, this item was showing the tentative date of 23rd of January, but it is not in the list of 23rd. I am praying that this matter be listed
Some date.
next week, Your Lordship.
Please give some date. Next.
But not between 3rd to 5th of Feb, Your Lordship.
That.
Okay.
Note kar lena. Yes, 803.
My lords, in 803, my lords, I am requesting for not to be deleted on 23rd January, my lords.
Date. नहीं है ना?
My lords, the computer generated date is of 23rd January, my lords.
23rd, it's not there, but give it.
My lords,
Give some other early date.
as per my lords convenience, any date can be given on next week. Monday,
Yes, you will give it.
deeply obliged, my lords.
Yes. Are the OBC reservation matters listed at item 120? Our petition, my submission was that if this court could take up our interim relief application, because similar people have been granted appointment of different categories.
If application comes, we'll take.
Our application interim relief is still pending.
Get it listed. Get it listed.
If that could be listed at least, sir.
Mention to the Chief Justice. Get it listed. File an IA and list it. We'll hear it. All the next.
Because this way, sir, the other category people have been granted appointment. We are discriminated. Yes, sir.
If it is listed, we'll hear whatever the matter is.
So our final, actually, can interim application be heard, sir?
If it is listed, we'll hear it, sir. What is
We list, could a date be given for listing, sir? This way it not come.
application is not before us. Mention it. Put it up. Yes, Mr. Patwalia.
In that PSEL matter, Your Lordship is now taking it up after lunch. I have discussed with Mr. Giri. My problem is there is a part heard which is kept at 2 and I have to be on my legs. So by the time Your Lordship reaches that matter, I may be arguing. So kindly excuse me, Mr. Giri and me have discussed. But as soon as I finish, I'll rush here, my lord. That's the only grateful. Great.
No issue.
May please. Lordship, this is at West Bengal legal.
Senior is appearing to BC.
Who is appearing?
Maninda ma'am.
Let them do it. These people have been worked. Yes.
Copies of the note.
Who is appearing?
Maninda ma'am is appearing through
In the
BC.
matter,
Kindly unmute.
kindly unmute, my lords. I'm appearing in the matter.
Yes.
So, your lordships had asked on Friday for us to seek instructions.
You're for the state of West Bengal.
Yes, my lords.
No,
So
how
the-
long will this go on?
My lords, your lordships had asked us whether we want to frame rules or not. My lords, the roadblock that we are facing is that when these people were appointed, my lords, they were appointed without there being posts and my lords on totally
You're
temporary
coming
basis.
back to square one, then it looks like,
Your lordships, may I request, your lordships, may I request? Your lordships may permit us, we'll place our affidavit on record stating our difficulties and then, my lords, we'll leave it to your lordships, we'll argue it, my lords.
We'll leave it at that also. Dismissed. Next. Call the next case.
Your lordships may kindly hear us, my lords.
No, leave it at that. Now we have,
My
given.
lords may kindly hear us, my lords, there is lot to
Enough
say in
now.
the matter.
That's enough. We have heard you.
Because today I was unwell, so I'm not in the court. Your lordships may
Doesn't
have
matter.
it next Monday, your lordships.
There's sufficient. People have been working for years together. You
Your lords
can't just do that.
may just listen to me, my lords, that's all. May hear me next Monday, my lords.
Tell us what is it?
My lords, what happened was these people were appointed totally on temporary basis. And because it was written in their appointment letter that they will not be made permanent. There is no post for that. And thereafter, Lords, we tried our best. We could not get the finance concurrence because of that reason. Because on the ground of parity laws for the government, other similar employees will also come. These are not even irregular appointments. There were no posts, no procedure followed. Therefore, I am saying, Your Lordships, it
They
will
are
take some
working
time.
since 2013. Thank you. Dismissed. Next.
Most grateful.
Obliged, Your Lordship.
Next.
May I please, Your Lord?
Please, my lord.
I'm appearing for the petitioner wife, my lords. The matter is referred to
Letter.
mediation. Unfortunately, it was not settled. I'm praying for transfer from Delhi to Hyderabad, my lords.
Is the letter in this?
No, my lords.
There's no letter? Okay, all right.
Page 13, my lords. HMA from
Refer to mediation. Huh?
Mediation.
Failed. Well, divorce petition. FIR is still pending there.
FIR, nothing is happening, my lords. I've been informed that it is stopped at a stage. Nothing is happening. So her father has just had a very bad train accident couple of years
Transfer
back.
it, sir.
My lord, I have filed my reply also. They have not filed any return. I have submitted that they are ex parte before the trial court. Ex parte evidence has been led. Matter was partly argued also. When it was being argued at the time, they brought the
Evidence is complete.
No, my lords, I've been...
My evidence is complete. They are ex parte. They have not filed any application for set aside ex parte order.
No,
Ex parte arguments have been heard. It was to be listed for judgment when they brought the stay order.
no, my lords, I was informed that it is...
Till date, they have not filed any application for setting aside that order.
This is a
No.
reverse petition is of which year?
This is of 2024, my lords. He has filed the HMA in 2024.
We'll transfer it. Transfer. Next.
Obliged, my lords.
I'm appearing for the petitioner wife, my lord. There are two applications which I have filed. One is for my lord directing him to pay arrears of maintenance of around 3,93,000.
Bhavnagar.
Yes, from Mumbai to Bhavnagar, my lord. And another is, my lord, he has appeared on 1st of April.
That FIR, right?
That FIR, my lord, was culminated into 498A proceeding. That proceeding is disposed of, my lord. Now nothing is pending over there. Except this matter, my lord.
Except that the divorce only.
Previous petition was dismissed.
So nothing remains. Previous same item was. Why are you reviving it again?
My lord, the reason is that there was an order of, there are several orders of maintenance where he is not paying the maintenance. Second thing, my lord, there is a medical issue in the...
Service is complete. Where is... Why are you not paying maintenance at all?
Sir, I am paying maintenance. I have all receipts and all.
No,
because of COVID or some little, I think 50 or something thousand, I have to pay. I clear all the payments.
It's 3,93,000 which is pending, not 50,000.
No, sir. I already told him to give
address, memo of address which he has provided.
She didn't tell anything.
The police
don't even pay the traveling expenses.
Nothing is being paid.
Don't pay traveling expenses. Don't pay the maintenance.
Final stage.
Support
Final argument stage.
How do you do? This is a
and family stage also argument stage, sir. Final argument stage.
My lord, this was in 2018 which was filed.
2018 matter?
Yes.
Stage is the process.
Stage is, my lord, witness box, his evidence has started. That's it. I have not come. Cross has not been concluded, my lord.
Sir, already all are done, sir. Now is final stage. Argue final stage.
That is a wrong submission. I am appearing in
sir,
the...
I will submit. If you want, I will submit the family court list.
You have transferred it. You are not cooperating. You are not giving her anything.
No, sir. I am cooperating everything.
No, we are transferring.
And before 2 times
transferring,
also,
if you appear
she
through.
filed Supreme Court and Supreme Court rejected.
Petitioner is permitted to appear through.
Before already 2 times he filed Supreme Court. And Supreme Court already rejected.
Thank you. Dismissed. Allowed. Next.
I am highly obliged.
Item 4. No children.
Because item 4, the petitioner was supposed to take instruction for mediation, my lord, before the Supreme Court.
But if you failed, mediation is failed.
The previous round of mediation was failed, my lord. I was arrested outside the mediation center, my lord. In this case, lordship may recollect, my lord. So we requested mediation to be before Supreme Court. They sought in time to take instruction whether to agreeable for the Supreme Court mediation or not.
What is appearing? What happened? Who is there? Asor.
Milord, I am seeking time to file my counter. 4 weeks time may be given, Milord. Criminal transfer petition pending. I have to file.
Want to file a counter?
I want to file counter. I am for respondent number 2, 3 and 4, Milord.
The domestic violence case as well as the other.
Milord,
the
3 cases are pending.
protection case is also pending.
3 cases are pending.
They have filed
they are appearing.
even another transfer petition that is regarding matrimonial divorce petition, Milord. That is not listed here. So I have to place certain.
All right.
4 weeks time may be given, Milord.
Request to the council for the respondent. 4 weeks time is started. All right. 3 weeks earlier.
Item 3.
This is a guardianship and a custody case.
Well, I am appearing for respondent wife in this matter, Malits. The mediation has not worked out, Malits, and in fact, Malits, they are seeking transfer. Wife and child, they are staying in Agartala.
How we will? The child is with whom?
With me, Malits, with wife.
Then how can it be transferred?
It cannot be, Malits, as per section 9 also, Malits, it cannot be.
Who should know?
And the divorce petition is going on, Malits. They are deliberately, Malits.
Child is with the mother. Both of you are saying at Gurugram. Is it?
No, Malits. It is incorrect. I am staying in Agartala, Malits. I have stated so.
What does he make that statement?
Malits, it is an incorrect statement.
Pass over.
Please, Your Lordship, I am appearing for the petitioner wife. The matter can be referred to mediation. There is some scope of reconciliation between the parties.
Yes, we would like to explore the possibility of mediation.
Mediation. But we can transfer it also. Otherwise, all cases are pending there at Ahmedabad. Why don't we ask it to be done in Ahmedabad? Huh? Why can't we ask the mediation to be done in Ahmedabad after we transfer the case? Because there are so many other cases and there is a child also with the mother.
Please, Your Lord.
Correct?
Yes.
There's also a child.
It's a 80-year-old minor.
Yes, tell us.
Your Lordship, earlier also they came to a settlement in which they could not get into the settlement. They signed the agreement, but it could not be effectuated. So it is a better forum for both of them to.
All right, mediation.
Your Lordship, parties may be permitted to appear virtually.
Yes. We see.
So great.
8.
Please, Your Lordship.
Please, Your Lordship. Item 8, Malits, we are seeking transfer from Lucknow to Ranchi, Malits. The respondent has filed a counter yesterday, Malits. He's saying, he himself admits, Malits, there are 3 proceedings pending in Ranchi. He is participating there.
Your Lordship, 3
matters are pending.
Pending before Ranchi. I am working in Lucknow. Now 3 matters are there. I have to visit there in every.
Already 3 are there. So we'll anyway be visiting. So we'll transfer this.
Your Lordship, there is a domestic violence case. The Honorable Court ordered for 10 lakh compensation, 5 lakh compensation and maintenance. We are ready to give them the maintenance.
There is a DV case, there is a maintenance case, there is a criminal complaint also. All 3 are pending.
He's participating as well there.
Lordship, we are ready to abide by the condition of the Honorable Court. They directed us to pay the 20,000 rupees maintenance. We are ready to provide them the maintenance.
It's a different matter. Transferred.
Next.
In item 9, Lordship, a mediation proceeding was initiated before the High Court. A report is awaited. And I have instructions that parties have ongoing mediation process.
Lord, these are, my Lord, 2 legal aid matters, my Lord. They were assigned to 2 different lawyers. My Lord,
this is by the husband and the
husband, my Lord,
father-in-law.
Husband, my Lord.
Yes.
Marriage.
See, transfer of FIR. How can we transfer FIR and DV?
That's right.
Lordship, the situation of the family is too bad. Father-in-law is also 80 plus now. And husband has already suffered a tumor operation and all. So if something can be, it's a very pathetic situation.
Fight the FIR and how can then?
In one case, it is the state party, and another case, wife, which is between husband and wife.
Be done. This
is a criminal proceeding.
Dismissed.
Absolutely.
Next.
Grateful.
Item 10,
my Lord, at least allow him to appear through VC in some.
VC is part of it.
Obliged, Lordship.
Yes,
item 10, my lords.
The petitioner never appeared before the counseling court. Last time it was adjourned, the lower court in Pune. But asked them to appear on both dates. She did not appear.
My lord, she has a baby, my lords, of 9 months old, my lord. Two children, my lords. 9 months old baby, my lord.
This is a case for transfer.
Yes, my lord.
2 children are there with her.
The petitioner, the respondents are, my lord, in-laws. And they are all senior citizens. And, my lord, they are in Pune. And it will be very difficult for them to go to Chandigarh, my lord. With all due respect, my lord.
From where?
From, my lord, Pune to Chandigarh.
Pune to Chandigarh.
So what I am respectfully submitting is that the matter for reconciliation or mediation, my lord, the matter was before the trial court. He deliberately doesn't appear twice, my lord, after having appeared before.
Mr. Ranjit Kumar, this is an exceptional case because it won't work because she has 2 minor, very, very children.
Not 2 minor, my lord. I'll tell you, lordship, my lord, the first husband, the husband who, my lord, who's dead today, the in-law's son has died. The child is 10 years old.
Correct.
We are seeking custody as grandparents of that.
But even that child is with the mother, no?
Yes, my lord.
That child is with the mother.
And studying in the school.
Second marriage has not given a new child. The second marriage, which otherwise under the Adoption and Maintenance Act, they cannot have that they can keep custody. That's the law, my lord. Even the husband whom she has married, he has also got a previous child of 10 years.
I know that.
So therefore, there are 3 children here, not 1, 2, 12, 10 years, and 1 small baby who has been just born. What we are respectfully submitting is that under law, if you have a child from your previous wife or a previous husband, then, my lord, if you have a new child, that's under the Act, my lord, Section 7 and 9, then you can't have the adoption. You can't take a person in adoption.
Wait, who is the adoption?
No, we don't want adoption.
No, my lord.
There is no adoption.
No adoption.
The second husband today has adopted this child.
That is the family has adopted.
In Ludhiana. To make, my lord, a jurisdiction, though everything happened in Pune.
Oh.
What I am respectfully only submitting, my lord, that the mediation should be tried by the Supreme Court once. It's a matter, my lord.
They have not come. Are you not cooperating?
My lord, the thing is she is not able to travel. Not able to travel, my lord.
She can appear.
She can appear by VC, my lord.
She can appear through VC.
Yes, my lord. But, my lord, the thing is that I also asked her personally 2 or 3 times from some mutual relatives. They already had some talks, but they are not on the terms of getting the things mediated because the respondent is firm of having the guardianship of the child and she is not ready to give up the guardianship.
Anyway,
that's the thing. So mediation, my lord, will ultimately fail.
We'll transfer it.
Yes, my lord. Let it be at Delhi, my lord.
My lord, it's far out.
With all due respect.
But she can't leave the entire.
Citizens, my lord, to come.
There's a
citizens to come, my
You
lord.
can see the respondents. We will say that they can appear through VC. Transfer Karlina. We allow the transfer petitions. We make it clear that the respondents can not get into all that. Respondents can appear.
Pleadings there will not count, my lord. The pleadings in the transfer petition, some reckless allegations have been made against.
Absolutely, we'll clarify that. The respondents will be entitled to appear through VC, except when the court specifically wants them to be personally present. Stop. That is when some mediation. The amendments made in the transfer petitional will have no bearing whatsoever on the main proceedings before the transferee court.
Please.
Oblige me.
May I please, my lords. It's in a different combination. It was heard.
Yes.
So, my lords,
heard for some time. The bench broke. We just never could assemble.
It's a very short issue.
पहले तो वो डेविड सिक्रो the two variants. Sorry, वो सब वो होगी ना on the table. So I will be telling them.
We'll take it up on some day.
Yeah, Manoj can either today also it can start if the combination is going to stay the same, then your lordship can start it today also, subject to what your lordship
But these are 82 individual professors, PhD doctors,
yes,
who have been discriminated grossly by way of a regulation which
all
is
right, all
invalid.
right. Fixing and don't you please raise your pitch.
Yes.
Just wait a minute. We'll just finish the miscellaneous board. We are actually in a part heard.
Oh, right.
And the bench is only till lunch.
Yes.
We are hoping that we can complete the part heard at least.
Then we'll not have it next. We'll wait, my lords, if the part is getting over, then we'll wait, my lords. We'll take our chances
It's a
today.
different bench. That's the reason.
No, till 1 o'clock, we'll take our chances till 1.
2 p.m. is a different combination.
Yes, yes.
He doesn't know.
Yes.
Not still 1, we'll take our chances.
The volumes which are sent yesterday are not brought on board. Some additional documents filed have not.
Let it be on Tuesday.
Those are all documents were there.
Only one request, my lords.
Then
Earlier we had made the comparison, but since the combination changed, we thought we should again send the
we'll
comparison.
put it on Friday.
Can I make a request?
Next Friday.
Can I make a small request in this?
One request, my lords.
Would your lordship keep it?
No further compilations, my lord. Every hearing, one day before we get 3,000.
Same compilation, but since
All right, no.
we had to rewrote it again.
You can add the document, but don't say all the documents.
No new documents are put.
May I just make a small request?
Item 13.
This your lordship, may I just make a small
Sorry,
request?
lordship, keep it 2 o'clock minutes on Friday or
Your lordship, in this,
It will come on Friday.
on Friday. Very good.
in item 12, I have just one small request. There's some connected matter. Your lordship tagged with the matter not listed today. We're just handing up the order. We listed along with this matter. Your lordship already tagged them.
13, the Taekwondo Federation of India. Elections were conducted to this federation under the orders of the Delhi High Court. Be recognized. One letter saying that Taekwondo India is recognized. I go to the court. The learned single judge passes an order with the division bench order, my lord. One division bench says withdrawal of recognition. The government can decide what it wants to do. That give notice for withdrawal is point one. Point imposter has been made a party to my withdrawal proceedings.
Question to be decided: who is the imposter?
Yes. So, my lord,
There will be another case which they said you are.
Just see page 211.
To decide.
Just see page 211. The judge did, and I never filed an appeal against that.
Not a case for us.
But lord, just see page 211. Stop from
This is too much
functioning.
Too much of interference in sports. Nothing of this is actually work. And inter se fights between the organizers is a very
Lord,
sports in our country.
And the learned judge has given a finding that there is a serious controversy regarding the way the other side was set up. Just see pages with me, because the learned single judge passed a very rational order according to me, leaving it open to union. Just see page 211, para 40. Leave it.
That's okay. Come to the High Court judge.
The High Court single bench first. 211. Single bench put the whole thing in the lap of the government, saying, you decide what you want to do. Now the High Court changed to me withdrawal of recognition.
Yeah, all this is all become in a way redundant because the Courts Act has come into force, and under the completely new regime is there. So interstate disputes between you and your rival, and perhaps December 2019 decision is to grant recognition in favor of respondent number 3.
Just kindly see the High Court direction, my lord, at page 11, the division bench direction.
Yes.
This is coming completely out of the blue. The appellant shall issue a show notice to respondent number 1 in terms of the sports code for withdrawal of recognition, option of suspension there is an option they may not do anything. Directly the High Court says withdraw recognition. The appellant shall issue a show cause notice in terms of the code for withdrawal of recognition within a period of 5
order of withdrawal, it's only to give you a show cause.
Yes.
That's
now kindly see the next direction.
file a reply, that's it.
Yes, but then they have been. Respondent number 2 shall make submission to the appellant. After respondent 1 submits a reply, respondent number 1 shall submit a reply to the submission of respondent number 2. This imposter has now been made a part of my withdrawal proceedings. He has been superimposed into me.
Appellant shall decide, see, eventually whatever may be.
Yes, decide the issue with regard to recognition. Within a period of 6 weeks from today and
bottom line.
Till the decision is taken. Now just contrast this with what the single judge did. Please have page 211, para 48. Kindly contrast these directions with the single judge.
All this arose because of.
Which is better? The single judge, just kindly see, I don't want to put it in my own words. Allow me to read para 48 at page 211. Para 48 at 211. Allow me to read this para.
Where is this 4/12/19 order?
The 4/12. It is reproduced. It is reproduced at page 185. The single bench has reproduced it. Yes, but at 185 it is there. The concerned international federation issued a communication dated 4th December purporting to recognize India Taekwondo as the sole national governing council and withdrew the recognition. Said communication is, shall I read it or not? World Taekwondo has been monitoring the situation in India for the past months. Due to good governance issues and multiple complaints, federation was preliminarily suspended.
Doesn't matter, you skip that.
Yes. Now just see the finding which the learned single judge gives for them. That is very, very crucial. They say, just kindly see at page 206, para 42. It is also noticed that there is a serious controversy surrounding the manner in which respondent number 3 was incorporated and came to be recognized. It is then the learned single judge says, my lord, I have very short grievances.
In the decision of the appellant with regard to the recognition of the sports, neither R1 nor R2 shall act unless he is fine. So correct. This is contrary to the single judge direction. Single judge has quashed. Because it's a division bench, it's entitled.
No, that is right. That is right. Now, my lord.
Okay, Mr. Patralia, leave it at that. Thank you.
My lord, allow me to function. My lord, allow me to then function till the decision is taken. Because the players are suffering. State events are suffering.
State is there. State is looking into it. And then the recognition has already been granted. Official one. So it won't be proper for us to do that.
It has been set aside. That order of grant of recognition has been set aside by the single judge, 8th May, and upheld by division bench.
This is an appeal.
Yes, correct. They have upheld that order.
Leave it at that. I think some sanity should come to sports in our country.
The only point which I feel
Thank you.
Division bench should not have said direct withdraw. There are so many options.
No,
Single judge.
You're right. But then they said that as a measure, till a final decision is taken, that's not a completely end in itself. It said it's the process of inquiry.
The world body has stopped entertaining me now. That's the problem I am facing.
We understand.
Now, Union of India is directed to reconsider this is the single bench gave the correct direction actually.
Okay, Mr. Patwalia. Next.
As NSF, if we are not functioning,
14.
everything falls flat.
May I please, Your Lordship, in item 14.
Today, my lord, my friend is right to say that there is a complete vacuum because there is no national sports body in Taekwondo. No national event takes place.
And it is but they have this is not taken away.
If your lordship sees,
issue notice to the government of India, he'll happily do it.
Lord, if we can serve the union, my lord, let the union come and at least.
Sports are already amicus in all sports are. So every sport is coming.
I'll be quite happy if he looks into this also, my lord. And I have, my lord, there are two practical issues. One, the division bench has given us completely death sentence straight away. The single judge said, reconsider, decide what you want to do. Division bench said, issue show cause notice for withdrawal. There is suspension. There are lesser proceedings. And division bench says both not to function. So today there is a complete vacuum. National events are completely gone. If I can issue, if only we can be allowed to function, we can serve the union in the meantime, my lord. There is a problem here. If
It is at your instance all this happened.
no,
Because you went to the court.
yes, because we were,
Challenging,
yes, because they granted,
Not in the normal courts. It
they granted recognition to a parallel
turning
body.
back and complaining.
So they granted recognition.
All right, Mr. Patwalia, leave it at that. Thank you. Dismissed. Next.
No, then let's. May I please, Your Lordship?
My lord,
Item
we have
14.
got
15.
just one. My lord, we have got a show cause notice. We have filed reply. Allow me to withdraw it to pursue those proceedings to their logical.
After some argument, Mr. Patwalia seeks to withdraw the specially petition. Permission granted. SLP is dismissed as withdrawn.
Great. Great.
Lords, in this,
Your
the
Lordship,
extended
item
date comes to an end on 20. In item 14, the extended date for admissions comes to an end on 23rd,
Pass over, Your
which is why we have a little bit of an urgency. I understand my friend is asking for a passover, but the date is 23rd, my lord. So that's why we are in a bit of an urgency on this. The last date is 23rd.
Humbly seeking pass over, Your Lordship.
I understand your lordship's bench is till 1 p.m.
1 p.m.
That's the problem, because the urgency is the extension has been granted only till 23rd. We had mentioned it for listing.
Tomorrow. Come tomorrow.
Very well.
Is seeking a direction to reduce the hours and time for admission.
Yes, really. Yes. Item. Item. None is appearing. Petitioner, none is appearing. And what do we do?
Looks maybe a date, my lords. Next week I'll inform them also. I've already tried calling them.
Actually, this is a case for transfer. That's why.
Lords, I agree with that, lordship. Only point of mediation, my lords, he has lost his job. He was a police officer, my lords.
Yeah,
because of the arrest, he has lost his job. Now he's really will settle.
He already has to face 4 cases there.
My lords,
Yet another case.
Supreme Court can put a quietus to everything, my lords. That is why I am pleading, my lords. Let me take a chance of next week the matter might come. Let them be also here, my lords. Next week, my lords.
From what? From Tiruttanni to Tirupati?
My lords, every case may be sorted out, my lords, because the mediation could not go through, my lords, over there. He was arrested, my lords, when he went for the mediation there.
Advocate for me. Why could you not have just... It seemed to have listed a number of times.
Mediation has failed. That's what I report.
If mediation has failed, what more?
My lords, may I please submit, my lords, this case, lordship may recollect, my lords, he was a police officer, my lords, he went for the mediation. When he came out of the mediation,
What does that
my lords, mediation could not effectively take place, my lords. Now, after losing his job, my lords, he is in a position to really settle the matter, my lords. That is why I am seeking, my lords, because this every matter may be put to quietus, my lords, because all the criminal complaints and the divorce case, everything.
Next week list.
Please, my lords, oblige.
Just inform the other side.
I'm appearing for the
Yeah, tell us.
matter. For wife, my lord, she is staying along with her son, my lord, in Agartala, and they are seeking transfer of.
Already the child is.
My lord, she.
The mother.
My mother, child is staying with me, my lord, in Agartala. And my lord, they are seeking transfer of GWA.
Dismissed. We are dismissed.
My lord, obliged.
My lords, may I just interrupt for a moment, my lord?
Yeah.
Your lordship had asked for a list of the provisions that are actually impugned and how they were dealt with. May I hand over the chart?
I am appearing in a writ petition.
Just 1 second.
Yeah, I'm sorry.
This is just a chart, my lord, indicating the 7 areas which were impugned. The second, my lord, I don't mean to interrupt. This is the chart, my lord. And we've given the responses of the two judgments. Take it, sir. Your lordship had indicated.
Very well.
Just one small point, I don't mean to interrupt later, my lord. There are extended arguments, my lord, being made on section 23 on the last occasion.
Files there.
Those are not the subject matter, my lord, of impugnment. I just want to state that. We will respond if your lordship wants us to. Please go ahead. I'm done now.
That I am appearing in a writ petition that after my learned friend finishes, that today I am in some difficulty, but I think my learned friend will go on today.
This bench is only for a half a day.
That's right.
Half a day today.
So
you will get about an hour's time. Yeah. Okay. We'll see. We'll see how it goes. Yes.
Just give me my file.
Yes. Yes.
May I please, Your Lordship?
Yes.
May I please? I was placing the provisions, my lord.
Yes.
I was placing the provisions, my lord. Your Lordship.
Get the act. Oh, act then. Under the endowment. There were two volumes, one volume consisted of all the acts. Why volume, it had the pre-amended and post-amended.
01.1.
No, kya kar rahe ho?
No, it's in the second appeal, my lord.
Yes, it had both.
Sri Mahaganpati Shankara Devasthanam. That will have the acts. CA 4103. नहीं एक सेकंड 5 नहीं है क्या एक सेकंड 4103 last time it was 5 it is changed because some were withdrawal हो गया ना पिछली बार 101.1 this time वो 4 मैटर डी टैग हो गए थे तो नंबर्स बदल गए पॉइंट में 4103
First of the
The amended I'll come I referred only for limited purpose.
It's not being followed.
Sir, you are master of
Maybe. I'll accept that.
Yes, Mr. Bhatt. What's your tell us your proposition and then make your submission.
Yes, I was indicating my broadly.
Broadly, you tell her what is your submission and then you articulate, please.
Yes, my lord. I indicated it the other day, my lord. My submission is, my lord, as far as because we have impugned section 25 primarily, taking over the management of these religious institutions, temples, my lord. That, my lord, would offend Article 25. Because under Article 25, we are in.
Which section will offend 25?
Section 25 of this Act. Section 25 of this Act.
Amended as well as amended, both.
Yes, yes. Both.
Will affect Article 26.
23 read with section 25.
Will affect Article 26.
25 as well as 26. There is a submission below. Under Article 25, Lord, our right to propagate religion, because that is also an equally fundamental right to control of the management as well as the control of the funds is essential for effective propagation of religion. That be, propagation of religion is also an equally recognized and fundamental right. Not taking over management, denuding us of the power of wielding the funds.
So 25, 23 and 25 could go.
Yes, that is a submission.
Could go. But will the entire act fall?
My Lord, quite a few of the provisions, my Lord, chapters are linked to that. Therefore, my Lord, other provisions also.
So second submission is that many provisions are inextricably linked to 23 and 25.
25.
Linked to 23 and 24.
Because
therefore, no severability.
Yes, appointment of archers, appointment of staff, etc.
Whatever.
All those things, common pool fund, etc., etc.
You should make good that argument.
I'll try and make good that argument.
Then
there is the first limb of the argument. Second is, my Lord.
First limb is 23 and 25 are unconstitutional. Second limb is that if those go, the rest of the act will not sustain. What is the third?
Third is, my Lord, in the event of your Lordship not accepting this, an alternative argument, my Lord, our right under 26, because Hindus as a whole are also to be considered as denomination. They also have to be given the rights under 26.
So, in other words, you are saying that I have my 26 right and 26
A in particular.
26A right. For that you will have to prove denomination.
No, my Lord. Your Lordships have laid down the test.
No, formulate your point.
Yes,
so you are a denomination.
Hindus as a whole are denomination.
Whatever it is, you claim to be a denomination. Next.
So therefore 26A, C and D are offended by this act. That is a broad submission, Mila. I will place the constitutional provision for the purpose of clarity, Mila. May I do that, Miller? Lordship's permission?
No, it's all right. Any call? No, I'm on 26. What is the better article here?
Yes, Mr. Bhatt?
Yes, Miller. May I placing 25, Article 25, Miller. Freedom of, with your Lordship permission, may I place it, Miller? Freedom of conscience and free profession, practice and propagation of religion. So, Lord, in my humble submission, propagation is protected as much as, Lord, the professing and practicing of religion. all the decisions, my lord, which deal with the what taking over of management, my lord, were with regard to what is its impact on the right to practice religion, my lord, and profess to a certain extent. Lord, those decisions would not have any relevance for the purpose of the submission that I am making. That propagation is also affected because this is not in my humble submission, management of the institution as well as the funds of the institution are necessary for effective exercise of that right. Therefore, my lord, your lordship may see, subject to public order, morality and health, and to other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. Rest of it may not be necessary for my purposes. So propagation is also being on the equal footing as the other two rights. Third, when you take over management and deprive me of the control of the institution and deprive me of the funds and the wherewithal through which I would be able to effectively exercise the power of propagation, Lord, it will be unconstitutional under section 25.
Show us some laws.
Yes, Lord, I will do that, my Lord, once I place 26 and the provisions, my Lord. I will place the provisions also, my Lord. Certain decisions which would, my Lord, help my contention according to my submission, my Lord. It is ultimately, of course, subject to your Lordship's approval, my Lord. And freedom of 26, my Lord. Freedom to manage religious affairs. Subject to public order, again, morality and health. Every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, C, to own and acquire movable and immovable property, and to administer such property in accordance with law. My Lord, this act, by notifying our institutions and then, my Lord, taking over the notified institutions, offend 26A, C and D. Because as far as B is concerned, your Lordships have said it is only confined to practice of religious ceremonies, and that is, my Lord, well established now, my Lord. Therefore, the right to establish and maintain institutions for religious and charitable purpose. This, my Lord, your Lordships have interpreted to mean establish and maintain. Maintain is also inclusive of right to administer. That is what your Lordships have said, my Lord. So, right to administer an institution of a denomination. If my argument, my Lord, my submission with regard to Hindus being a denomination, then, my Lord, 26A would be attracted. So, equally so, my Lord, 26C and D. Therefore, the provisions of the Act, my Lord, fall foul of 26A, C and D in my humble submission. And now I will go to the provisions of the Act, my Lord. The Lordships were, I will quickly again, my Lord, go to the definition section, my Lord. Your Lordship may look at the section 2, no, section 1, my Lord. Section 1, subsection 4.
You use the same paper book.
No, my Lord, I have my own Act.
Somebody follow up and then tell us the pages.
209.
Do that. 209.
This is the amended latest Act, my Lord.
Tell us. Tell us, Mr. Bhatt.
Yes, my Lord. Section 1, subsection 4. It shall apply. May I please it, my Lord? It shall apply to all religious institutions or charitable endowments notified under Section 23. Section 53 and Chapter 8 shall apply to all religious institutions or charitable endowments other than those notified under Section 23. The 23, my lord, provides for notification of institution. And my lord, clause 20, my lord, defines what is notified institution. Notified institution, may I please repeat that? Clause 20. Notified institution means an institution notified under Section 23. Page 213 I was told. Page 213. Lord, I would also, my lord, bring to your lordship's attention the definition of Hindu religious denomination at clause 16, my lord, would be the earlier page. Because institutions belonging to Hindu religious denomination as understood by them are exempted from operation of the Act by Section 35. The lordship got it, my lord? My lord, Justice Narasimha got it, my lord? 16. 16. Clause 16. Hindu religious denomination means a collection of Hindu individuals or devotees classed together under the same name. A Hindu religious section or subsection or a body or a section thereof, or spiritual fraternity represented by it having a common faith, ritual, observations, ceremonies, mode of worship which is designated by a distinctive name. This is the understanding of a Hindu religious denomination by under the Act. So those institutions. Now these institutions are exempted under Section 35. In my humble submission, it is an artificial definition of Hindu.
They are exempted under Section
35.
Let us see them.
Yes. Two 239 below. Page 239. May I please it below? My lord, Justice Narasimha got it?
Yes.
Section 35. Lord, Justice Arati got it below? Except applicability of the provisions of the Act. Except the provisions of Chapter 8. Nothing contained in this Act is applicable to any religious institution or charitable endowment founded, organized, run or managed by religious denomination. Nothing contained in Chapter 7 shall apply to a notified institutions whose gross and...
There is no such exemption to the rest of the Act.
Pardon me?
There is no such exception to the rest of the Act.
As far as Hindu...
Only talking about exemption from Chapter 8.
No, I'm sorry. Except the provisions under Chapter 8, nothing contained herein. In the Act shall apply to denomination.
Except 8. What is the Chapter 8?
Chapter 8 is, my lord, with regard to declared institutions, my lord, where you have mismanagement, etc., etc.
Declared institution.
Yes. It is also defined, my lord, declared institutions. Under 42, institutions which are found to have mismanaged the affairs of the institution are declared after notice. Then you may put in your temporary management. That nobody defeats. We are not really impugning. In my humble submission, my lord, accept this Chapter 8, rest of the provisions, if my contention finds favor with your lordships, would go. 8 would, because if nobody has a right to mismanage, that of course nobody can claim. whether denomination, non-denomination, anybody, then the government or the authorities are duty bound to step in. That too for a temporary period. But my lord, this 8 is the only redeeming feature of the, according to my submission, my lord, of the act. Rest of it, my lord, because they are interlinked, but they cannot operate on their own. Entire thing, my lord, this is the keystone. So 23 and 25 are the keystone of the entire act. If that falls, which I have humbly submitted the position here, the entire arch would crumble. There is a submission for your lordship. Lord, I placed 23 now. My lord, your lordship, for sake of completion, my lord, what is declared institution also, it is my duty to clause 11, my lord. Section 2, clause 11. Page 211.
Oh. Yes.
Declared institution means an institution declared under section 42. And your lordship saw section 42. Now coming to the key provision, or section 23. Two to 8, page 2 to 8. May I place it? The state government shall, as soon as may be after the commencement of this act, publish by notification in respect of each revenue district a list of all charitable institutions, Hindu religious institutions, which on the date of the commencement of this act are in the sole charge of the state government under the provisions of the Mysore Religious and Charitable Institutions Act 1927, or for the benefit of which any monthly or annual grant in perpetuity is made from public revenues, or trustee allowance under section 19 of Mysore Religious Charitable and Charitable Inams Abolition Act 1955 is paid. All institutions registered under the Book of Endowments under the Hyderabad Endowment Regulations 1349 firstly, all institutions governed by the then Madras Hindu Religious and Charitable Endowment Act 1951, all religious institutions registered under the Bombay Public Trust Act 1950. This, my lord, as I was submitting the other day, is amendment to the act brought about in 2011, the latest amendment. Earlier, my lord, as I was submitting, only those institutions registered under the Bombay Public Trust Act which received some kind of a grant from the government was covered up by this, under this provision. Now, my lord, irrespective of the fact that whether an institution receives any grant or not, the moment it is seen that it was registered under the Bombay Public Trust Act, it would be notified as a notified institution under 23. So, my lord, it is an all-encompassing, my lord, drastic provision taking over. And like my learned friend, Mr. Vishnu Jain was saying, my lord, 34,000 institutions, religious institutions, small, big and medium, have been taken over now under the have intend to be taken over at least under the provisions of this act. All all Hindu religious institutions which are in receipt of any monthly or annual grant from public revenue or any amount under the Karnataka Certain Inams Abolition Act, Sri Renuka Ellamma Temple, Saundarthi, governed under the Renuka Ellamma Devasthan Administration Act 1974. Now coming to the governing provision below, section 25. I place it. I've got it. Constitution of the Committee of Management. There shall be constituted in respect 25 million.
25?
Yes. This is a provision, my lord, which is impugned along with 23 primarily.
Yes.
There shall be constituted in respect of one or more notified institutions by Rajya Dharmika Parishad if the gross annual income of the notified institution exceeds rupees 25 lakhs and Jilla Dharmika Parishad if the annual income does not exceed rupees 25 lakhs, and a committee of management consisting of not more than 9 members from among the devotees and followers of Hindu religious institutions and beneficiaries of the charitable institutions, and it shall consist of, in the case of a temple, a Pradhan Archak or Archak, at least one among the scheduled castes and scheduled tribes, 2 women, at least one from among the persons living in the locality where the institution is situated, provided that in case of composite institutions, members from both Hindu and other religions may be appointed. Provided that the committee of management in respect of notified institution be constituted.
Is for notified
Condition. Yes, please.
Chapter आई करना by basic further.
Yes.
Provided further that the committee of management in respect of notified institution be constituted according to the usage and practice prevailing therein. Provided also that every committee of management or Pancha committee or Dharmadarshi committee or non-hereditary trustees constituted or appointed under the repealed acts who are lawfully holding office shall cease to hold such office from the date of commencement of the Karnataka Hindu Religious and Charitable Endowment Second Amendment Act. So without the earlier management goes, the Rajya Dharmika Parishad and the Jilla Dharmika Parishad, while constituting...
What are the aspects you are challenging here? You just tell us.
Pardon me?
What are those aspects of it which you are challenging here? What are about 25, part 26, 23 we are done. It's the overreach according to you. You haven't made that point about 23.
23
you just finished 23. What's your argument on 23?
23 and 25 put together, both of them put together, because 25 is not the self-operating kind of provision.
Correct.
The 23 and 25 together will not come into operation. 23 notifies the institutions, all the religious institutions as they were submitting, even those which do not receive any grant, etc., etc. You notify it, then you are the government or the management goes out. You appoint a management in its place. Therefore, our right to manage is taken away. And in my humble submission, 25, Article 25, right to propagate, it is integral to manage the institution also. Without that, I cannot exercise that power, that right, under 25, right to propagate. Right to propagate, an institution which is, a religious institution, would...
what is the right to propagate? What are the constituents of that according to you?
Disseminate,
What is it that they are? This committee under 28.
Yes.
28. Look at the scope of interference or management. What is taken over? Is it a secular activity or is it a religious activity?
No, Milord, there is no. As your lordships have laid down, Milord, as far as right to profess and practice are concerned, I bow down, Milord, the secular activity would not, Milord, constitute the Milord, the right, fundamental right. That, of course, I bow down that. Milord, there is a position that your lordships have repeatedly held. But, Milord, the as far as propagation is concerned, there, Milord, there is no distinction between, Milord, the religious, essential religious functions as well as secular functions. Because it is secular, Milord, management is a secular function, of course. But then without management, I cannot exercise that right of propagation.
What is a propagation?
Milord, I am a religious institution. I want to, Milord, for an example, Milord, the temple. That temple, Milord, I wanted to start a Ved Pathashala, let me assume. There is also propagation of, Milord, our ideals, our religious teachings, etc., etc. Milord, now the management is taken over by this particular body. I cannot do that. I do not have the funds, control of the funds. The funds will be controlled by this management. Therefore, the right to manage is also, administer also, is a fundamental right under the umbrella of propagation. There is a submission for the lordship country. Therefore, I am not bringing in, Milord, essential religious practices, etc., etc.
So how it's get curtailed?
Pardon, Milord?
Okay, you complete the provisions and then show us later whenever you want.
Yes.
How that gets curtailed.
Yes, I will place certain decisions which say, Milord.
How that under the act gets curtailed is also.
Yes, of course, I will have to do that. Milord. Because the entire management goes. The funds also they will manage. I cannot. I am out. I am out for all purposes, including appointment of staff, etc., etc. Everything done by them.
Yes.
Yes. May I submit the entire provision, Milord, first?
Do whatever you want.
Yes. I was reading second proviso of subsection 25(1), Milord, provided also that every committee of management or pancha committee or dharmadashi committee or non-hereditary trustee constituted or appointed under the repealed acts who are lawfully holding office shall cease to hold.
Yes, Mr. Bhatt.
I will read it again, Milord. Provided also that second proviso of subsection 1 of section 25. With your lordship permission.
You want to read?
Second proviso.
20?
25 only. I am on 25 only. Because I was midway of placing second proviso.
Yes.
Provide, my Lord Justice Narasimha.
Right, go ahead.
Provided also that every committee of management or pancha committee or dharmadashi committee or non-hereditary trustees constituted or appointed under the repealed acts. So therefore, my Lord, these all the managements, erstwhile and managements, is referring to all kinds of erstwhile management. Repealed acts who are lawfully holding office shall cease to hold office by operation of this provision.
Yes.
From the date of commencement of the Karnataka Hindu Religious and Charitable Endowment, Second Amendment Act 2011. So this is the one which virtually, my lord, takes over the management from our hands.
Correct.
2A, the Rajya Dharmika Parishad or Jilla Dharmika Parishad, while constituting the committee of management under subsection 1, shall have due regard to the religious denomination to which the institution or section thereof belongs. But I do not know, my lord, how it will operate at all, because under your lordship's section 35, religious denomination as understood by them do not come under this. But still they say, my lord, as far as possible, the denominational adherence will have to be looked into.
Sampradaya.
But there is a definite meaning given to religious denomination here, my lord.
Then?
The procedure for the constitution of the committee of management, verification of antecedents and other matter, if any, of the members shall be done in such manner as may be prescribed. No person shall be eligible to become a member in more than one committee of management at a time. No person who is an office bearer of any political party at any level
This is the only one. This is the only one. Yes, Mr. Bhatt.
Yes, sir. No person who is an office bearer of any political party at any level shall become a member of the committee of management. No person shall be qualified for being appointed as a member of the committee or the management of a notified institution unless he has faith in God, he has attained the age of 25 years, he possesses good conduct and reputation, and commands respect in the locality in which the institution is situated. A person shall be disqualified for being appointed or continuing as a member of the committee of management of any notified institution if he is declared as an undischarged insolvent by a competent court, if he is of unsound mind and stands so declared by a competent court of law, or if he is deaf or mute or is suffering from a virulent form of leprosy or contagious disease, or if he has an interest, direct or indirect, in a subsisting lease of any property or in a contract made with or in the areas of any kind due by him to such institution, or if he is appearing as a legal practitioner for or against the institution, or if he has been sentenced by a criminal court for an offence involving moral turpitude, such sentence not having been reversed or offence pardoned, or if he has at any time acted adverse to the interest of the institution, or if he is an office holder other than archaka or servant attached to or a person in receipt of an emolument or perquisite from the institution, or if he is addicted to intoxication, liquor or drugs, or if he is not a Hindu or having been a Hindu converted to any other religion. If a member of a committee of management is or becomes subject to a disqualification under subsection 4, he shall automatically cease to be such member. If any question arises whether a member is or has become subject to a disqualification under subsection 4, the Dharmic person may either suo motu or on a report made to it, or after giving an opportunity of being heard to the person concerned, decide the question. So that is the provision, my lord, 25, taking over the management.
All right.
Lord, now that your lordships are on section 25, I will place 25A also, my lord, exempting provisions. Temples managed by hereditary trustees exclusively, my lord. That may also be a little relevant. 25 capital A, my lord. May I place it below? Provision relating to institution managed by hereditary trustees. No committee of management shall be constituted in respect of a notified institution, even though it is a notified institution. managed exclusively by hereditary trustees. The power of management shall rest in such hereditary trustees. If there is no legal heir to succeed to office of the hereditary trustee, the Rajya Dharmika Parishad or Jilla Dharmika Parishad, as the case may be, shall constitute the committee of management as provided under section 25. When a temporary vacancy occurs in the office of the hereditary trustee, or if there is a dispute with regard to right of succession to such office, and such vacancy cannot be filled up immediately, or when the successor is a minor or has no guardian fit and willing to act, or there is a dispute with regard to as to who is entitled to succeed to such office, Rajya Dharmika Parishad may appoint a fit person to discharge the functions of the office of his until the disability ceases or when the successor succeeds to the office. Provided that in making an appointment, the Rajya Dharmika Parishad shall have to due regard the claims of the member of the said family, if any, entitled to the succession.
What is the meaning of this in 25 second part? The power of management shall vest in such hereditary trustee.
The lordships are referring to, my lord,
25A later part.
25A, my lord. 25 capital A, my lord? Yes. The power of management shall vest in such hereditary trustees, because notified institutions, even if it is notified under 23, if it was exclusively being managed by hereditary trustees, then, my lord, this 25 would not apply. That is the net effect of it. 25 would not apply. You would not appoint management of nominated by you. They would not appoint the under 25. 25 would be excluded. So it is virtually an exception to 25. 25A. So my little point here is this, my lord, only in a case, of course, where there is a hereditary trustee who has appointed, he has co-opted, supposing, he has co-opted some trustees. This provision, my lord, only says if it is exclusively governed by, temple is exclusively governed by hereditary trustees. Even if he has co-opted one trustee, my lord, outside, then this provision would not apply.
Under what provisions are they declared?
Pardon me?
25A.
25A is an exception carved out from section 25. 25 capital A, in effect, is an exception to section 25.
I think 215.
Madam,
definition clause.
Yeah.
Definition clause.
Yes. 15, that's right. Hereditary office holder means an office holder, and hereditary trustee means a trustee of a Hindu religious institution or charitable endowment. Succession to office of which, to whose office, devolves according to the law of succession or declared as such by any court of law or by any statutory authority or recorded as such under any enactment.
In the first place, they are anyway out of country.
Is it identified under 23? Is that in notified institution?
Yes.
Under 23, where does such an institution fall?
No, my lord, under 23, they notify, my lord, your lordship, see, various institutions, my lord, which were registered under.
No, just we are wanting to know, that's all.
Yes.
A side question.
Yes.
No committee of management shall be constituted with respect to notified institution managed exclusively by.
Yes.
This notified institution managed exclusively by hereditary trustees.
Yes.
Where are those mentioned is what I am asking, what we are asking.
My lord, it is, position is like this. My lord, under the erstwhile acts, all institutions, public institutions were registered, my lord.
Correct.
So, your lordship sees.
Therefore, once it is a notified institution,
they get
it should
notified.
fall under 23 only. What it says that for such institution falling under 23, the committees can't be exclusively of
That's right.
hereditary.
That's right. That's what I'm saying. That's what it is.
There's no doubt about it.
Yes.
But then the later part, the power of management shall vest in such hereditary trustee.
Yes.
So that power of management exclusively vests in such hereditary trustee. And how does that get reconciled with 24?
No, 24.
Because it says the subject to the jurisdiction of the commissioner.
Yes.
Powers of the commissioner shall be chief commissioner.
Matters connected with the notified institution, he shall perform such duties and exercise such powers as superintendent. That is with regard to notified institution.
25 along with the provisions.
Notified. Everything is a notified institution. Everything will not be found. Yes, Mr.
Yes, madam. Now the constitution of these dharmika parishads, because that will be relevant because they are the ones who are authorized to.
Some portions were struck down.
Yes. Section 20, madam.
Yes.
The state government may Justice Narasimha got it, ma'am? The state government may by notification in the official gazette constitute the Rajya Dharmika Parishad consisting of the following members, namely. Now, your lordship looks at the committee constitution, my lord. Minister in charge of Hindu religious institutions and charitable. So he is a political personality. Secretary to the government in charge of Hindu religious institutions. Again, my lord, the bureaucrat under the political personality. Commissioner, Hindu religious institutions and charitable endowment. Again, not a bureaucrat. Members nominated by the government. Again, political appointee for a period of 4 years. Members to be nominated by government for a period of 4 years. One retired district judge, one Agama scholar, one Vedic scholar, one person belonging to SC or ST, one person belonging to backward classes, one woman, 2 others. The members nominated by government under subsection 1 except a retired district judge shall hold office subject to the pleasure of the government. Again, my lord, it is whims and fancies of the government, my lord, of the day. Entirely, this Dharmika Parishad. It virtually becomes a tool in the hands of the government, in my humble submission, my lord. Quite apart from the fact that, my lord, in law, as a matter of fundamental right, whether they are political or non-political, my lord, my right would not depend upon that, in my humble submission. But even so, this provision, the members nominated by government under subsection shall except the retired judge shall hold office subject to the pleasure of the government. The members nominated by the government shall be a person who has contributed to Hindu religious field but shall not be an office bearer of any political party at any level. See, your lordship notices this, my lord. He shall not be an office bearer of any political party. He can be a member of a political party. So this is a field of political patronage, my lord, virtually, this Dharmika Parishad. In the event of any vacancy due to death, resignation and otherwise, the government may appoint a member for the remaining period of term of such member. The Rajya Dharmika Parishad may, for the purpose of consultation, invite any person having experience and specialized knowledge or expert in any subject to attend its meeting, and every such person is entitled to such allowances as may be prescribed. The government may delegate any of its powers and functions other than the power to make rules under the provisions of the Act to the Rajya Dharmika Parishad. The rules making power also is, my lord, vested in the Rajya Dharmika Parishad.
You understand?
In the absence of chairman, vice chairman shall preside over the meeting of the Rajya Dharmika Parishad. In the absence of nominate member, the remaining members constituted in the Rajya Dharmika Parishad. All correspondence, etc. That may not be much relevance to us, my lord. Now, section 20A, my lord, again. The power and functions of the Rajya Dharmika Parishad shall be follows. The Rajya Dharmika Parishad shall be empowered to resolve any dispute regarding religious practices, custom, usage, traditions. For their purpose, it may consult experts to assist it as to whether a temple is a public or private or denominational temple, as to whether an institution is a religious institution or a composite institution, as to whether a trustee holds or held office as hereditary trustee of such institution. Now, my lord, the most important provision. Section 2. Rajya Dharmika Parishad may constitute a committee of management. Your Lordship saw it in 25, my lord. And this authority, my lord, the Rajya Dharmika Parishad constitutes. So basically, my lord, it is the Rajya Dharmika Parishad is a, my lord, handiwork of the government. Through the Parishad, the government appoints the management, and virtually the government has taken over from practical purposes. Make Rajya Dharmika Parishad may constitute a committee of management to the notified institution having gross annual income of rupees 25 lakhs and above, may approve scheme for adoption of temples having an income of rupees 2 lakhs or less, or fix the terms of adoption, shall act as a...
Will continue.